are present here. So we are delighted to welcome our 3 days international workshop under the title of Intellectual Property and Rights, especially for the patent. This is Dr. Sathishkumar Sankar from IAS Shibpur, West Bengal. Already I shared last 2-day recording through that WhatsApp group, so you can utilize that. And PPT also I shared through the WhatsApp group also. So unfortunately, we are not continue this session up to 5 days. So we want to conclude today. So in meanwhile, so we will share the feedback form and the Google review link for you. So you please submit your valuable feedback as soon as possible. Do you have any queries during the session? You can stop at any time. So we will discuss. Then we are moving on for the slides. Thank you so much for giving this wonderful opportunity. Please work with me. So today's session I want to cover, which is starting from the grants of patent, rights of patentee, and what are the things, what are the provisions available under this Act, patent 1970s, the patent of addition, and the amendment of patent application, and the register of patent, and compulsory licenses. So these are all the things that we are segregated the 2 days. So I want to complete a single day. So unfortunately, I want to travel tomorrow from Calcutta to Bangalore. So only we are taking the step of that decision immediately. So please accept our request. Please understand for your situation. Thank you so much. Then I'm starting from the grants of patent under the section 43. The grants of patent is nothing but where an application for a patent has been found to be in order to grant of patent and either. So if the application is satisfied all the needs, what are the things is required in the controller and examination point of view. So all the documents available, all the claims is justified, that claims are new and that claims is not claimed earliest before the patent application or priority date of that particular application. So first thing we want to consider here sorry, the application has not been refused by the controller by virtue any power vested in him by this act. So all the documents is in that applicant side, we should submit all the documents and what are the things required by that controller. So we want to submit all the documents. So the controller, there is no rights to refuse that accepting or refused to accepting that our document and refused to grant the patent. So we want to follow all the protocol. So controller or examiner, they are thinking like that. All the controller or the examiner, they are thinking to grant the patent, but the applicant should satisfy their needs. So based on the different type of the forms and different type of the procedure, we want to fulfill in that particular controller and examiner point of view. The application has not been found to be in contravention of the provision of this act. So that's the most important things. That application, already I mentioned that under the provision of this act, the secrecy direction section 35, if imposed in particular patent, a particular invention, that particular patent is not flow further. So once the secrecy direction is removed from that particular invention, then only it's moving on further process. So that particular patent is not contravention of any provision of this act. So that is the most important things. We get that particular successfully getting the granted patent. Third things. On grant of patent, the controller shall publish the fact of patent has been granted, and thereupon the application, specification and other document related thereto shall open for public inspection. Once the patent is granted, So controller is open to give that particular document, particular patent document and a particular application. So what are the specifications they are mentioned through the applicant side. So it is open for the public. So anyone can read, anyone give that post grant opposition. So already I mentioned that yesterday. So within 12 months, anyone can file post grant opposition. So it can be possible. So once the patent is granted, all the documents available to the public, so anyone can inspect that particular documents, anyone can give that opposition within 12 months. Subject to other provision of this act, every patent shall be dated as the date on which application for patent filed. So already I mentioned that. So there are different type of the provisions available in this particular Patent Act 1970. So if the patentee is not involving any infringement, any malpractice in this particular invention, so they can claim the patent granted date is the patent publication date. So from the patent publication date, they will claim that particular invention as a granted date. So what is the condition is apply? So the patentee is not involving any such type of that malpractice or any such type of infringement. So once they are satisfied these conditions, so they eligible for that patent publication days as treated as a patent granted date. So the date of every patent shall be entered in the register. Okay. So generally we know that so the register will be maintained by all the patent office. So who is the real patent owner means which name whose name is available in the in the particular register. They only that owner of that particular patent. So every patent shall be entered in the register. So you want to make the renewal fees every year. So you want to maintain that your patent and the patent detail in that particular patent register. So rights of patentee under the Section 47 Patent Act 1970, they are clearly defined that. So where the subject matter of the patent is a product, here the condition is applied for is a patent is a product, the exclusive right to prevent the third parties who need who do not have his consent from the act making, using, offering for sale, selling or importing for those purpose of that particular product in India. So once the patent is granted, the patentee having the full rights up to 20 years. So after the 20 years, it's going for the public use. Anyone can use that particular invention. But within 20 years, that patentee having the rights to making that product or using that particular product or offering for sales, anyone can, the patentee can sell that particular invention to any corporate industries or normally that government industry. So any industry they can sell that particular invention. They can importing that particular product from India to other countries. The full rights, the patentee having the full rights under the section 47. They are clearly mentioned that the patent rights of patentee. And next things, if the invention is the process. So first thing we are discussed about the product. So second things it's discussed about the process. So same things, the exclusive rights, the prevent to use the third parties without his consent from the act using that process from the act using, offering for sale, selling or importing those purpose of product obtained directly by the process in India. So, if that patent is granted, it may be that particular patent is a product or process. It depends upon the patent. So, patentee having the rights to resell and offer for sale or import every rights. It's the patentee hold that particular rights up to 20 years. So, no one can ask the question. So, why you are using this type of this patent or like that? The controller and examiner that the patent office they are not involved with this type of this such type of infringements. So patent once the patent is granted, patentee having the full rights, they can take decision what are the things is required that particular invention, so they can take their own decision under the section 47. So patent addition, so this is important things I want to tell here. Patent addition is nothing but under the section 54, they are clearly mentioned that, so once the complete specification has been filled, or once the patent is granted, but after the days, the patentee is thinking any improvement that particular invention, or they can do any modification of that particular invention which is not failed to fill that main invention. That time, that applicant can give the request to the controller to request to give the request to controller to file the addition of that particular patent. Some claims he can add in this particular main invention. So that is called it as a patent addition. Already the patent is granted, or already patent is under the process. That times the controller that time that the patentee can give the request to addition of the patent. So some it may be that existing method which is not disclosed, that existing method, some improvement and modification of that particular product or process, where the invention being improvement in modification of another invention, subject matter and independent patent, the patent addition revoked the same date of patent grant. Okay, that that here they are clearly mentioned that it may be that invention, it is not it's not clearly the patentee also take the decision for that. So if it is possible, the patentee can add that particular inventions with the main invention, main as a patent addition. Sometimes he can file the independent patent also. So he can file the independent patent. So once the patent is granted, so once before that the patent is not issued, the patent is not granted. That time he given the application to that addition of that particular patent, that portion also is available. The patent shall not be granted the patent addition unless date of filling of the application was the same later than the date of filling of the application respect to the main invention. Patent addition, if the today I have filed one patent. So today morning I have filled, but today evening I am going for patent addition, means that is not work out. That time it is called it as an independent invention, or they combine that both invention, they combined the patent addition in that main invention also. So once the patent is processed, once the patent is granted, so then it is possible for the addition of that particular patent. So if the any modification or improvement is takes place, the patent addition shall not be granted before grant of the patent for the main invention. Here we want to follow that main invention. The main invention is a primary things. Once the main invention is published, then only it is going for that patent addition for evaluation, or grant that patent addition also. So before publishing, before granting the patent addition, before granting the main invention, the patent addition is not granted by the patent office. So terms of patent addition I have clearly mentioned here. Subject to provision contained in this section 55, they are clearly mentioned. The patent addition shall be granted term equal to that patent of main invention. Okay, the main invention, I got the patents within 1 year or 2 years, means that time. Just 1 minute. Just 1 minute. Sorry for the inconvenience. Sorry for the inconvenience. I got some call. Okay, fine. Terms of patent addition, here they are clearly mentioned that the term of that particular patent additions is equal to the main invention. So main inventions, I got the patent grant last year, means again 19 years I have that particular rights of that particular patent. If I am adding the patent additions after 2 year, after 3 year, means rest of the year, what are the rest of the years of that main invention, it's applicable for the patent addition. The rest of the year, 17 year or 16 year, means that is apply for the patent addition also. They are clearly mentioned under the section 55. If the main invention revoked under the Patent Act, the patent addition shall become the independent patent for remainder term of main invention. Okay, sometimes the main invention, it may be some infringement is happened in that particular main invention. That time the patent revoked. It will be happened sometime. Patent, the main invention is, if main invention is revoked, means that patent addition treated as a independent patent is a remaining term of main invention. So in this main invention, no renewal fees for the patent addition, but any such patent become the independent. Normally, if you file the patent addition, already published on some patent, so we are a modified something or improvement, we are filing the patent addition, means we want to pay the renewal fees of that particular patent addition. But if the patent, the main invention is revoked, that patent addition treated as an independent patent, that time the what are the fees the patentee is paid for main invention, they should pay the same fees for that particular independent patent. So which is earlier in that patent addition, that main invention is, once the main invention revoked, it is treated as an independent invention. When it is under the patent addition, there is no renewal fees. But once the patent is independent, the patentee should pay the renewal fees as per the protocol under the section 55. Okay, amendment of the application. So here we can see there are different type of the amendment is came under the section 57, clearly mentioned that the applicant and patentee allowed to amend the provisional or complete specification at any time as per the prescribed manner, and the controller shall not pass any order allowing or refusing the amendment of the application. Once the patent is filled, so any time, so before the grants of the patent, at any time, the patentee can amend that particular specification. It may be the provisional specification or it may be the complete specification. That's not a matter. But the patentee having the rights to amendment that particular the invention. Sometimes we are don't know that the patent agent also is sometimes failed to anticipation of that particular invention already claim or not. So that times already it may be some claim is claimed some persons after the date we are filled the application, means that is the infringement. Already the claim is there. So our claim is infringed, that existing thing, means it will be that it will be going for the wrong, and it will be affected our invention. So that times we are identified also this type of the claim is already available. So we want to amend our application. So that is selfly we known that particular invention is having some infringement. That time we can amend our applications before granting the patent. So the controller, there is no rights to allow or refuse that amendment of the application. The nature of proposed amendment and the application provide full particular of the reason for which application is meant. Because what is the reason? So as a patentee, we want to give the proper reason. So why we want to do amendment of that particular provisional or complete specification. So that's most important thing. So because generally, no, so our reason is valid. So without the valid reason, it's very difficult to that processing everything. So reason is valid. If your reason is valid for amendment of that provisional or complete specification, that controller, there is no rights to refuse the amendment of that particular application. Any application amendment after the grant of patent, the nature of proposed amendment may be published. Oh, once the patent is granted, so you want to amendment of that particular granted patent means it's possible. So you can amendment the granted patent also, but that time you want to pay the publication fees. The amendment it should be published by the patent office. So as per that Patent Act 1970, you should file the Form 9 for publication of that amendment. What are the things the proposed amendment should be? It sometimes as per that amendment is some of the amendment is a little bit some of the amendment is they are taking that too much of the correction is happened. The granted patent means it should be published by the patent office. These decisions are fully taken is responsible for the controller can take this particular decision whether that amendment should publish or not. But if you taking the major corrections at that time, it should be you should file the Form 9. So for the patent publication, it should be published by the patent office. The amendment of complaint specification may be include the priority date of the claim. So already I mentioned that priority date. So if you are amendment of complete specification, so already priority date already I mentioned that once the patent is published, if you are not involving any infringement until the patent is granted, so you can claim that what is the patent publication date as a treated as a patent granted date. So it will be happen in this particular portion of that particular act. Yeah, Rajesh.
Yes, audible.
Uh, yeah, Rajesh. Some person is sending WhatsApp message. So can you look into that?
Sure.
Okay. So register of the patent. So here we can see there are different type of the content. There are different type of the particulars can be registered in the patent register. So subject to provision of this Act 1970 is contained in this section 67. The following particulars should be entered in the register. So this is the most important things we want to know that. So every patent office they are maintaining their own register. So, what are the things they are takes place in that particular register? First things, the name, address of the grantees of the patent. So, name and address of the patent grantees. So, it should be registered in that patent register. Second things, notification of assignment and transmission of the patent, amendment, extension or revocation of the patent. So everything so we want to mentioned in the patent register. So if any assignment, the controller any assignment to the patentee, or they want to transmission of the patent to transmission the patent is from one say it may be that it may be the patentee is claim the process or product. It may be it is that claim is most probably it's suitable for that any process related invention. There are different type of the invention is there. So it may be any transmissions happen that particular invention. They should mention in the register and amendment, extension, revocation of the patent. So everything it will be registered in the patent register. So other matter affecting the validity and proprietorship of the patent may be prescribed. So these things, the most important, we know that, aware about that. So what are the things it will be registered the patent register. So power of controller. So there are different type of the power is there. The different type of the controller having the uh, full power to summoning and enforcing the attendance of any person and examine him on earth. So controller having the rights anytime at any person can call any inventor. The controller can decide that so he want to more information or some of the invention is it's happen infringement is infringement means so anytime the controller can ask any inventor given someone and enforcing the attendance of any person examining him at his own way. So the controller having the full rights to examine any inventor at any time. So requiring the discovery and the production of any document. So requiring is a discovery of discovery and production of any document. So he can product he can that identify that particular invention is facing this type of the infringement activities. That time he given that any individual document he prepared what are the infringement happened that particular invention. So he can identify, he can given the summon to that particular inventor. And receiving evidence on affidavits. So in that, if you are filing the patent, the physical mode, so there are different type of affidavit we want to do. Previously, I have mentioned that first day session, sorry, second day, first day and second day sessions. I have mentioned that undertaking and undertaking like this. There are three different type of the undertaking is there. So all the undertaking will receive by that controller only. So issuance of issuing the commission for the examination of the witness or document. So yeah, examination, the controller only controller only framing the examination board. So they are having that rights to forming the examination board and examine the particular invention based on that patentee or any one of the interested person can give the request for examining that particular invention. And avoiding cost, so you know that if you are going for filing the invention in the physical mode, that times there are different type of the depends upon the forms, the amount will be collected. So all the amount will be collected by that controller only. The reviewing his own decision and application made with the prescribed time, prescribed manner. You know, initially the controller take any decision about that particular pattern. After that, he is thinking to reviewing his own decision. The he will enforce that particular decision to that patentee. So it should be that prescribed time and prescribed manner. So within the time schedule, he can review the own decision. So he can implement that decision to the patentee and any other matter which may prescribe. So rest of the things, what are the things it will be happen? The controller having the full rights to taking any decision of that particular patent as per the Patent Act 1970, Section 77. So working of the patent, the general principle applicable to working of the patent invention as followed. First thing, the patent granted to encourage the invention and secure that invention are worked in India on commercial scale and to fullest extent that reasonably practicable without undue and undelay. So all the patents should be. So what are the patents granted in Indian government? They are encouraged to encouraged to use that particular invention commercial scale, the fullest extent of that. What are the things is possible for that particular invention? It will be implement. It will be used by the peoples, or it will be used by that any patentee. He maybe he export or he can develop that own product. He can sell that particular invention to any corporate industries or normal industries. So that what are the things it's possible to use that particular invention in the fullest extent, it can be possible for that under the it can be the provision. It's available in the Patent Act 1970 Section 82. That they are granted merely to enable the patentee to enjoy the monopoly for the importation of the patent article. So monopoly is already I mentioned that the patentee having the full rights to the sell the patent or import or develop that particular product or process. It's a monopoly rights. The patentee having that rights to utilize that particular invention is the fullest extent. Then that's the protection and the enforcement of the patent rights contribute to the promotion, technological innovation, and the transfer to disseminating technology. So once the patent is granted, why the patent is granted? So first thing is the protection of the enforcement. So you know the patent. Why already I mentioned that in the first day session. So what are the things? Why the patent is need for government of India or country? So first things, the streamlining the protection, streamlining the invention and protection and the enforcement of the particular patent rights. It will be obviously it will be promotion of technological innovation and a transfer and a disseminating the technology in the world in that worldwide or the countrywide. So it will be useful for the society. It will be useful for the technological development, and it should be economically significant. So these things all these are all the things most important once the patent is granted. Some of most of the patent. So as a educator, as a faculty members, so we are doing effective research. So we are going for that patent filling based on our invention. So most of the invention is not going for the commercial scale. That is a big issue in India. So because some of the researchers they are stopped their patent application until that at the stage of the publication. Once the patent is published, they are not consider about they are not thinking about that particular patent. The patent publication is common thing. So patent should be grant. Once the patent is granted, it's going for the commercial scale or any import or export. So we want to commercialize that particular invention, then only it will be reach last people of in country or last people of that last people of the world. So that is the things is the most important things. If you are the educator, if you are the faculty member, if you are the researchers, so if you want to file any patent, any invention, so once the patent is granted, then only you have that responsibility to that particular invention should be go for that commercial usage. So until we want to work that particular patent, once the patent is published or once the patent is granted, the our work is not completed. Then only our work will be start. So that is the big issues in India. So many of the researchers, they are filing the patent, they are publishing the patent, but they are not they are not waiting for the patent grant, and they are not once the patent is granted, they are not showing interest for commercialize that particular product or process. So that is a big issue in India. The patent granted do not impede production of public health and nutrition, should act as an instrument to promote public interest, specifically in the sector of vital importance of socio-economic and technological development. Once the patent is granted, once the patent is granted, it may be that invention is exploit that human public health, and it may be uh, given that complication in that particular society development. Sometime it will be happen. So once the patent is granted, all the things is protected, is the safest things. That is the granted patent is the safest thing. So all that if I'm filing the patent in the biological material, so example I'm taking like that. Biological material means it may be in the patent evaluation. Some of the things we can, some of the examination has been done. But if you are going for the public health, it may be that if you are consume the public in that particular invention, it may be happens during that climate, during the existent atmosphere, it will be happen. So while we are consuming that particular invention like that biological material or any medicine means, it will be in that other circumstances we will face the any complication. Once the patent is granted, so everything is protected. It is not possible for protect everything. So what is the use of that patent granted? It is promote the public interest, and it should be the socio-economic and the technological development. So then once the patent is granted, anything will be some it is not guaranteed for the protection of the public health. It will be happens. There are different character will playing the vital role. So the meaning of that patent is granted. It is promoting that public interest and enhancing the socio-economic and technological development. That's all. The patent granted do not any way prohibit central government in taking measure to protect the public health. Once the patent is granted, so example for the biological material I will take. So if I'm taking I'm consuming the particular biological material. In that particular biological material, uh, once that particular material is granted, the patent is granted from the patent office. So because after that I have consumed that particular biological material, it will be collapse our body. It may be that exploit that our body means the central government is not taking the responsibility of that. The patent is granted, but that it will be happened that other circumstances that times the patent of the central government taking any responsibility to protect the public health, the consumer should be aware about that. Under the section 82 they are clearly mentioned that the patent are granted to make the benefit of the patented invention available at a reasonable and affordable prices to the public. No, once the patent is granted, the patent invention, so detail about that particular invention, the article, patent publication, and what are the drawings is available, what are the geographical origin, they are mentioned, everything, the abstract, everything is available for that. Anyone can use that with the reasonable and affordable price to the public. So anyone can, before we want to use that particular invention, consume that particular invention, we want to elaborately investigate that particular, what are the data available that particular invention. So then we can go. It will be reduce that complications which we will face in the future. So compulsory license. So compulsory license, there are different categories. So there are three different type of the reasons the compulsory license issued for someone. Under the Patent Act 1970, Section 84, they are clearly mentioned that at any time after expiration of the 3 years from the date of grant of patent, any person can request to the controller for compulsory license of patent on any of the following grounds. So once the patent is granted, after 3 years, anyone can give the request to the controller to get compulsory license of that particular patent. So under this ground only. So following what are the terms and conditions apply for that particular compulsory license, which is include. So first things, that the reasonable requirement of the public with respect of patented invention have not been satisfied. So the patented invention has not had not is not satisfied that actual requirement of the public, that time anyone can give the request to the controller to get the compulsory license under the section 84 Patent Act 1970. Second things, that the patented invention is not available to the public at the reasonable affordable price. Once the patent is granted, the patentee the patentee ask the higher price for selling or importing or developing the product, means it is not possible for reaching that all the peoples in the country. So that time we can give the request to the controller to get the compulsory license. So whether we want to clear about that particular invention is not available for public, reasonable and affordable price, that the patented invention is not worked in the territory of India. Some of the invention is working for only one state or two state. So that time, so one of the invention is used in Tamil Nadu, but in the Gujarat that invention is not worked means. So that time we can claim as a individual, as a residents of that particular state, we can give the request to the controller to get the compulsory license under this provision of the Act 1970, Section 84, 84C. So that clearly mentioned that invention is not worked in the territory of the India. So revocation of this compulsory license. So here we can clearly mention that. So what are the things? Once the compulsory license is approved by the controller, the compulsory license owner should be satisfied. What are the things is that what are the things is available in that what are the things is takes place for given the compulsory license within 2 years. The compulsory license the that expirations the 2 years. So within 2 years you should satisfy the following requirement and and or one of the requirement, one of that among this one of the requirement. The first one is the patented invention not worked in the territory India, but this is the reason the compulsory licensee got the license from that true inventor through the controller. So within 2 years, first things, once the patent is granted, within 3 years, that particular patent is not worked in the territory of India, then it's going for the compulsory license. Once the compulsory license is granted, within 2 years, the compulsory license owner should be work in the particular patent which is available for territory of India. So otherwise, it is a revoke the compulsory license. Next thing, the patented invention is not satisfied the public requirement. Already I mentioned that. First things, 3 years duration. Second, once the compulsory license having the 2 years duration, within 2 years it should be satisfied the public requirement. Otherwise it's a revoke the compulsory license. And the third things, the patented invention is not available to the public in the affordable price. So these three grounds. So within 2 years the compulsory licensee should satisfy these three things, or it's failed to satisfy any one of the things. So the compulsory license will be revoked as per the section 85 under the Patent Act 1970. Okay. Terms and condition of that compulsory license. Here we can see that the royalty and the other remuneration is any reserved to the patentee or other person beneficially entitled the patent reasonable having regard to the nature of the invention. So royalty should be paid to that original inventor, the original patent inventor, but the patented invention is worked in the fullest extent of that particular person to whom license is granted and a reasonable profit to him. So royalty once the like a franchise, so you can easily understand the franchise. So that particular invention, nowadays the so many of that shops or so many of the corporate company, they are provide that franchise option. So they can use that particular name their own business. So that times they will pay some royalty to that particular inventor, particular patentee. That will be same here, the compulsory license. So, but that the patented invention should be used for the fullest extent and reasonable profit will be provided by that compulsory license owner. That the patent article are made available to the public reasonable affordable price. So once the compulsory license is issued, once the compulsory license is approved, after that the availability of that publication, the patent article and patent model or patent biological material or patent abstract, and what are the things is available that particular patent, it should be available for the affordable price to the people. So this is the most important thing. And next thing, the license granted is a non-exclusive rights license. We can uh, you know we can consume with particular duration, that particular we can use that patent granted patent through the compulsory license, but it is not exclusive license. It's a non-exclusive license. If the compulsory license owner is not satisfied that particular need, that time he can go for that. That time the compulsory license may be revoked. That the right of the licensee is not assignable. Okay, now next thing, that license is for the balance term of patent unless a short term is consist with the public interest. You know, that licensee, the compulsory license and the term of the compulsory license is the rest of that patent, up to 20 years the patent have the live only, na. So once the compulsory license issued after 3 years, it will be valid next 18 years. But anytime patentee or compulsory license revoke that compulsory license also. Licensee can revoke the license. So which is he is not satisfied that what are the things before I have mentioned that. So you should satisfy all the years. Every year they are having the review. You should satisfy everything or any one of the thing. So otherwise it will be revoked the compulsory license in that particular section 99. That the license is predominant purpose to supply the Indian market, and that licensee may also export the patented product. So license initially, so license, initially there are two different type of the option is available. So once the compulsory license is due, licensee can cover the Indian market. It is possible he can export that patented product uh, in that foreign also. Patent export the patented product in the foreign also. Sorry. It is depends upon the patent. It depends upon the licensee is having the capable for export the particular patent invention, so it can be possible. So last thing I want to cover here, the penalties. So what are the things the Patent Act will covering the penalty of impose the penalty to the impose penalty to that patentee or patent agent under the section 118 to 124. They are clearly mentioned that so contravention of secrecy provision related to the certain invention. So your invention is defense purpose or atomic energy purpose. That time it will be as per the Patent Act 1970, that invention is under the contravention. So you want to justify that, you want to if you don't disclose that particular contravention means it will be imposed by the penalties from the controller by the controller. Second thing, falsification of entries in the register. So if you the improper data or false data, if you entered in the patent register means, once the controller is identified that particular data is incorrect, that times some penalties will be imposed by the patentee or patent agent. And unauthorized claims of the patent rights, already the claims is there. So if you're claiming the same claims, it's not authorized means that time it is not under the Patent Act 1970 section 118 to 124. That time it will be happen for that unauthorized claim. So next thing, wrongful use word the patent office. As a patent agent or a patentee, so I know the patent office, the controller. I know that particular persons which is who is working in that particular patent office. I will publish. I will take that this particular invention. I will help to publish that particular patent or grant the particular patent. You want to pay some fees for me. So this type of that any persons involving this type of that in this type of the activities, that time the patent office imposed the penalty to that particular person if using that particular patent office name wrongfully. Next things, refusal or failure to supply the information. So anytime the controller or anytime the controller can examine that particular invention, it any person he can send the summoning for the any person who submitted that particular patent. So that will be if asking the controller is asking any question or any type of the clarification that particular invention means, we want to showcase, we want to justify that our invention, we want to give the proper information about that particular invention. Otherwise, he will impose that particular patent. He will impose the penalty for the particular inventor. Practiced by non-registered patent agent. So, every year the Indian Patent Office, Indian government is conducted the patent agent exam. Once you clear that particular exam, then only you are treated as a patent agent, you are treated as a authorized patent agent. Because some persons they are involving for non-registered, they are not writing the exam, they are not having the rights to having the rights to filing the patent and propagating that particular invention. So that time, if you are acting as a patent agent, is a non-registered patent agent means that penalty will be happens. So controller can take the necessary action decision to impose the penalty to that which person is involving non-registered patent agent and offense by the company. So these are the general offense. So we want to follow some protocol which is mentioned in the Patent Act 1970. So otherwise, some others like that other penalty also it will be included. So this is my end. So if you have any queries, please unmute yourself and discuss with me, please.